Any mention?
मैं इसी में सॉरी humid
Item number 1.
sino ka you state Where's Mr. Day? Has he filed rejoinder?
No, sir. No rejoinder has been filed by them.
Where is he?
And my lord, there's a new development in the case. On Friday, my lord, 16,000 metric ton of coal for which the Jimma was pending before the single bench of Mr. Bhattacharji, that coal was lifted by this Mr. Samuel Sangma illegally. And an FIR has been filed by me against the same.
Which Mr. Sangma?
Samuel Sangma, ex-MLA.
Where's the petitioners? Wait for some time, let them come. We'll call out the matter again.
Yeah.
Yes, call out the other matter.
Hearing item number 3.
Very please, Your Lordship. I have submitted the written submission, Your Lordship.
Mr. Guru,
My lord,
last occasion already given.
I have already given that apart, my lord, option was kept open for me, my lord.
Yes.
Just to the limited point of whether case diary can be, my lord,
Relied upon.
not exactly in my case, my lord, it is not relied, but my lord, there is a case of the Madras High Court has discussed all the Supreme Court judgments where learned trial court can exercise power to go through the case diary at the time of passing of judgment to satisfy itself as to the veracity of the evidences placed before the learned trial court. I am placing that judgment, my lord, and I have highlighted that with I'll give you one copy. Go through.
Yeah, but on section 60.
Open the citation. Let's see which one.
There's only one. There's a lot. Note. Okay, can you just you were just for the. Oh yes. Okay. You've got copy of his written argument.
Yes.
No,
By some
I have not received.
What?
written argument. You not receive copy.
No, we've received, sir. Directing argument we've received.
Yes, we have
Already,
received.
already.
Let's see the judgment.
That apart, my lord, I think Lordships has already gone through the judgment, my lord. The judgment is not based on case diary, my lord. The judgment is based on the, my lord, the evidence and that has been placed before the judge. So that is not a case where case diary has been relied on, my lord, for passing of the impugned
What does
judgment.
the judgment say?
Judgment, my lord, in the second page, my lord, is highlighted, my lord. Page 3, my lord.
Which paragraph?
Page 3, third paragraph, seventh paragraph, 7.
Every police officer.
My lord, I have highlighted a court is,
No, it's not highlighted in our copy.
my lord, not highlighted, my lord, is in bold
Bold.
italics. Yes.
Okay. Yes.
A court is within its competence to read a police diary as an aid, and that can be done to satisfy itself
To satisfy
its
conscience.
conscience in appreciating the legal evidence available on the record, but not beyond. So, my lord, in my case, my lord, in the impugned judgment, my lord, court has gone through, my lord. It is not that, my lord, the impugned judgment is based on, my lord, purely on the case diary, my lord. It is not.
In my argument, I have stated how it is based on as an evidence. Your Lordship. Everything has been I have given detail.
That is your
Yes, that is my
argument.
submission.
That entirely the entire conviction
Yes,
was
yes.
based on the
Yes.
case diary.
Even the PW4, no evidence has come forward, but she is picking up from the case diary as an evidence.
My lord, will further appreciate, my lord. This is a case where PW4 and PW6, the two IOs, they were examined after more than 2 decades, my
20
lord.
years.
The-
20 years.
20 years.
Even
more than
the ocular witnesses also.
Yes, my lord.
They examined up to 20 years.
Exactly, my lord.
True, but their statements were never recorded by
So,
IO.
my lord, I have
That is
submitted.
that is the drawback.
I have submitted my authorities, my lord. As a human being, they are bound to make some contradictions. So, therefore, my lord, that aspect may be taken into account, my lord. Deputy.
Yes. So, hearing concluded. Judgment is yes. Order. Jim.
Second call, item number 1.
Deeply obliged.
Yes. Because, yes, Mr. Advocate General. Where's the petitioner?
He's there, sir.
Yes?
He's there, your lordship. I'll go to call him.
Where is he? Call him straight away. Item number 1 for division bench.
My lord, my rejoinder is ready, my lord. I want to file it so the matter can be heard, my lord. My friend, I cannot locate my friend.
You
So he is here now. I will serve him a copy and I will file it.
You got a copy?
No, I will serve him now, my lord.
No, my lord. They had my number. They could have WhatsApped me or emailed me.
My lord, CD has come. If I email and all, something else will come maybe. So I have not taken the tricks, my lord. But I am filing it now only, my lord, positively.
And how will you take up the hearing today then?
Let it come up next Monday, my lord.
You have to have after 1 week.
No issues, my lord.
Mr. SD submits that the. You're appearing for whom?
Whole India, my lord.
But is Coal India interested
Well,
here?
it's not.
2nd of June? Now is the.
26th, my lord, of me.
Yeah, so 26th, 2nd of June is next week. It's after 1 week only.
Yes, yes, my lord.
2nd of June.
And my lordship, in the meanwhile, regarding that coal which has been lifted illegally on Friday,
You
this
file
Friday.
an affidavit.
Yeah, my lordship. I'll file an affidavit, and the state may be called for the report of the coal pending there in
No,
Gaswapad.
let you file affidavit. Whatever orders necessary, we'll pass it.
Okay, my lord.
Yes, Mr. SD submits that the rejoinder affidavit will be filed in the course of the day with advance copy to the respondent stub. You are MS? N Sangma? MS N Sangma on behalf of respondents number 6 praise that the matter on behalf of Mr. MS Ahmed praise the matter fixed on 2nd June. Accordingly, this is the matter on 2nd June for hearing. And also the respondent number, your respondent number, Mr. Bhama, your respondent number
14.
14 is also permitted to file an affidavit to bring on record other recent developments. Yes.
My lordship. Item number 2. Connected. Number 2.
Number 2. Same.
Any mention?
May it please your lordship. Your lordship, I beg to mention item number 19.
For upgrading?
19, your lordship.
For adjournment or for what?
Yes, your lordship.
For?
Item number 19, your lordship. As the arguing counsel is not here today, your lordship.
Arguing counsel.
As Deb, your lordship.
Yes, Deb.
Yeah.
Number 19.
Yes, your lordship.
Have you filed that application? Is fixed for what? Hearing on what?
7/11, your lordship.
Still interested in pursuing this matter?
Pardon, your lordship.
Is the election petitioner still interested?
I don't know, your lordship.
Have you got instructions?
No, your lordship.
He's not interested. See, many of the election petitions, they're just taking adjournments unnecessarily. You tell your senior, you get instructions whether he's not interested, file an application, we can withdraw it, we'll notify it. Yes, sir. MS Idhar, correct? Yes, has filed an adjourned petition application on behalf of the election petitioner. The same adjourned for the reasons stated therein. Yes, after 4 weeks, yes.
May it please your lordship. Your lordship, I beg to mention item number 22, your lordship.
Paulina Marak, yes. Yeah, who's for the petitioner? Yeah, objection.
Since you are asking that, no objection, I think. Yeah.
For 2 weeks, your lordship.
No urgency.
Actually, I just let him give one week, lordship. 1 week.
Give other 2 weeks. If you say yes, 2 weeks. Yes.
Okay, lordship.
Yes.
Must press, lordship. Please, your lordship, I beg to mention item number 20, lordship. 20. We come next week, lordship. Next Monday, lordship.
Lordship, this is the matter pertaining to offering of prayers.
Through movie.
No,
through movie.
Through movie.
Through movie, sorry. Yes.
Lordship, the matter has become infructuous.
Structures, yes, because you all settled.
Let it come
right
next
then?
week, lordship. I'll satisfy, lordship. There is a case.
It's just another
something to
tactic,
remain.
lordship, to delay
Still
all the
remains,
other
still
matters.
remains. They are trying to confuse something. We're saying that prayers have already been
But
performed.
the suit's only pending, correct?
Yes,
That's a
lordship.
different thing. That's a different thing altogether.
It's related.
As far as what we've come here, it's only our right violation of that.
That's over.
No, it's not over, lordship.
Lordship, I've brought a record.
Give us next Monday,
newspaper
lordship.
clippings that they have already performed.
Next
1
Monday.
week.
1 week. Thank you.
On a prayer of Ismarpan. Yes. Yes.
Please, lordship. I beg to mention item 26, your lordship. Lordship, I pray that this matter may be listed after 3 weeks, your lordship.
It's a pension matter.
Yes, your lordship. We are still awaiting documents from the DC, your lordship.
Your lordship, unless and until they submitted those documents,
You can't file affidavit.
Your lordship, you already filed.
We already filed.
Yes, lordship.
Just after 4 weeks, yes. On the prayer of the learned counsel petitioner to enable her to obtain the documents from the Office of Deputy Commissioner. Yes. Take 4 weeks, maybe we'll get by the time. Yes. Yes.
Lordship, I beg to mention item 21. Can come after 3 weeks. Lordship. Item 21.
Why?
Lordship, this matter, there's another matter pending in the division bench. Lordship. I'm just waiting some orders.
3 weeks, okay.
Hello, Lordship.
Yes.
Item number 1.
Please, my lord. My lord, the petitioner wishes to withdraw this petition. The reason being that the cause of action no longer exists now because
Mr. P.K. Bora submits instructions that may be allowed to withdraw this application. The cause of action no longer survives.
Obliged.
Matter stands closed. Dispose of on withdrawal.
Item number 2.
Yes, Mr. Dr. Saraf.
My lord, in this case, my lord, a fuel supply agreement was entered into, which you also find at page 129.
What agreement was entered into?
My lord, the event is that, my lord, as per the terms of the contract, my lord, in case there is supply less than 30%, then any party can consider the terminate the contract. Now, for 3 years, my lord, I gave the bank guarantee, I gave the furnished the performance guarantee, I gave the advance payment, but the supply was not made. Thereby, I issued notice for termination, no action was taken, and accordingly, my lord, I terminated the contract. After termination of the contract, my lord, they have also passed an order terminating the contract, and by forfeiting my bank guarantee, by forfeiting my security, and all those things. Now, lordship, you kindly see the clause, my lord. Clause 17 at page 157.
157.
But only one thing, my lord. They've given me a copy only for Union of India. Coal India is the main respondent, my lord. Coal India Limited.
Dr. Saraf, I think this to serve Coal India. They have a standing council. They have standing council. They are based in Guwahati only.
My lord?
The standing council is based in Guwahati only.
We can serve the copy, but only my lord, I can send Guwahati also, my lord. The only difficulty is that, my lord, my 2 bank guarantees have already been encased, and they are going to encase the other 2 also.
Where's the 157? You said, let us see.
My lord, 157.
You're purely a contractual dispute.
No, contractual dispute normally you are also in control. But in case the order which is in past, the action which is taken in clearly positive Article 14 of the Constitution of India, then your lordship can certainly interfere. 17, your lordship, page 157.
Yeah. Yes.
18, 17. The fuel supply agreement executed shall be valid for a period of tenure of agreement. Any premature achieved by the consumer buyer, except with the reasons of the exigencies, force majeure, operation issues faced by the supplier company, including change in the contracted grade, government regulations shall affect the following current provisions for the purposes. There also see now 17.2, and more particularly D at page 158.
Yes.
In the event the level of supply falls below 30%, or the level of lifting falls below 30%, or the purchaser or the seller, as the case may be, shall have the right to terminate this agreement after providing the other party with prior written notice of not less than so-and-so. However, such notice is to be issued within so-and-so day of the end of the relevant year, provided that the seller shall not have a right to terminate the agreement pursuant to this clause in the event that the level of lifting by the purchaser falls below 30% solely on account of the fact that the purchaser has been unable to lift the scheduled quantity due to shortfall in the quantity necessary for formation of the transportation through rail mode. Now, in this case, below the supply, there was no supply at all, not to speak of 30%, and thereby the purchaser has a right to terminate the agreement. Now, I terminated the agreement under 17.2D, Milord. Now, after receipt of that, they are terminating under 17.1. How that can be, Milord, if the clause clearly provides that the supply is not made at all, because the railway, Milord, the rates were booked, and thereafter the railway rates were cancelled. You lost me, kindly see, Milord, at page 228. These 3 railway rates were booked, and they were thereafter cancelled by them because of non-ability of the calls by the supplier.
Anyway, yes. Now, what to do? We need the attendance of the other respondents. Yes, Dr. Mozika, anything to say?
Will be only formal party. They can serve the matter can be listed tomorrow, day after tomorrow. They can serve Mr. Ahmad.
Subject to your lordship, approval, whatever is there.
Yes.
Only my difficulty is there that I will serve a copy and then your lordship will fix up the matter again afterward. But till then, whatever actions they are taking, they should not take till the next day, otherwise it will become.
Where's the interim prayer?
The interim prayer also. Other interim prayer I will not insist for at present. You will also see page 44. 45.
Yes.
Mainly 4 below.
How will we ask for refund of the amount now?
No, I'm not asking for the refund. In name pay of I'm sorry, Lord, 47.
Now the thing is that, see, at page 48, there's number 2. These other bank guarantees are still have they been in cash or is yet to be encashed? There's 47 lakhs and 52 lakhs.
Only 12 million, the 47 lakhs, that's not encashed.
Has been encashed.
That's not encashed. 47 and 50.
I can't hear you properly, Dr. Saraf. Yes. Yes, I can't. It's not clear. You said you have submitted that 47 lakhs been encashed.
No, the 2 bank guarantees of 11 lakhs and 10 lakhs have been encashed. This is still pending.
47 and 52.
Oh, yes,
okay, yes.
But only when it pays 272 lots. This is 18th of March, my lord. They can wait for 2-3 days, my lord. Let notice we issued to Coal India Limited.
No, that were encashed earlier.
272.
But this bank guarantee is encashed. I'm not saying you have to give the amount now. Only this is encashed, at least not let them give the bank guarantee.
We just give no further course of action be taken against the petitioner till next date. Yes. I heard Dr. A.S. Saraf, then counsel petitioner, issue notice. Dr. N. Mozika, Leonard DSGI with so-and-so's present behalf respondent number 1, who submits that respondent number 1 is in the matters only a formal party, and that the main answering respondents are respondents 2, 3, and 4, who are not yet been served in notice. The grievance of the writ petitioner company is with the action taken by the respondents 2, 3, and 4 with regard to a fuel supply agreement which is submitted by the learned senior counsel that the same has been breached by the said respondents themselves, and that the people themselves, and that in fact they have instead sought to take course of action against the writ petitioner by encashing the bank guarantees and security deposits that have been furnished in furtherance of the contract. He prays that in the interim, at least no further course of action be taken against the writ petitioner. Further counsel for the, having heard learned counsel for the petitioner, it appears as submitted that the dispute seems to be contractual. But however, until the appearance of the respondents number 2, 3, and 4, who the petitioner shall take steps to serve within the course of 3 days, no course of action shall be taken against the writ petitioner company till the next date. We listed on the 2nd of June. Yes.
Two words can be added below that we mentioned, Lord. No coercive wages.
Yes, we already said that. Yes. We already said that.
Including encashment of bank guarantee. Otherwise, again, interpretation will not, they will do it.
1 week only. Okay, we'll correct it. Yeah.
Item number 3.
Yes.
May it please the Lordship. Lordship was pleased to pass an order to call for records of title suit number 19 of 1982.
Yes.
Your Lordship, let's seek some more time, Your Lordship, since my senior is out of station.
Mr. Nongklao?
Yes.
The records as requisitioned by order dated 8/5/2025 since been received. However, what is your name?
K. Kariam.
However, Mr. K. Kariam, the counsel says that the matter became another date due to the absence of his senior, Mr. H. Nongklao. In consideration thereof, less after 1 week.
I'll oblige.
Item number 4.
This is that golf matter. My lords.
Yes, you start, Mr. Changri, so you are questioning the maintainability of the writ petition, correct?
Yes, yes.
Yes.
The broad outline of my submission on the maintainability of the writ itself is, my lord, the AGU is not the state under Article 12. And
IGU?
Yeah, IGU. IGU is not the state under Article 12 of the Constitution. And number two, my lord, the action of the IGU in question here today is not amenable to jurisdiction.
IGU is okay?
Yes.
Not
and the
that state.
third, there is an adequate provision for dispute resolution mechanism in the MOA itself, in the RR. Therefore, they cannot come before this court, even if assuming that writ is maintainable. But these three outlines, my lord, I have prepared since it purely focus on the legal issues. I would place, my lord, the decisions, 13 decisions to proceed, my lord.
Where's the, you said that's altered remedy, where it's contained?
My lord, that.
Where is it?
May I come to page number 77 of the writ petition itself. This is the rules and regulation of the IGU.
77.
My lord. RR 66, my lord. My lord. Para 6, RR 60, rules and regulations 66.
Okay.
Page number 77.
This is rule and regulation of?
Of the IGU. Where at the time of getting affiliation, all the affiliated associations, state level, agree to these terms and conditions voluntarily, and they accept the affiliation. Now this RR 66 is binding to all the affiliated associations, including the writ petition.
All unresolved disputes?
Well, all unresolved disputes shall be settled by the Arbitration Commission of Indian Olympic Association, and all affiliated members of the IGU shall voluntarily surrender their right of seeking redress in any court of law. Now, the interpretation given by the writ petitioner is that here the dispute is if, for example, the State Level Association of Meghalaya and the State Level Association of Bihar is in dispute, they can invoke this provision. That is a brief interpretation given by the writ petitioner. But our interpretation...
Bihar?
But this is example, my lord.
Oh.
Now, our contention is that, my lord, all the disputes between the, my lord, the IGU with the affiliates association or any other associations required to refer to the Arbitration Commission. Now, the elaborate provisions are there. May I place that?
Rule 66.
No. May I just place the elaboration of that arbitration clause. May I just submit this to court master?
Court master.
Just good. IGU and the other affiliated associations are governed by this MOU of Olympic Association.
This is of Indian Olympic Association?
Yes. And may I come to, my lord, page number 23, first flag mark.
This is called Memorandum and Rules?
Yes.
Okay, 1 second. Memo of Rules and Regulations of IOA. Yes.
My lordship, may I come to page number 23. RR 17.4, well, Arbitration Committee. It's the composition of the
Arbitration Committee?
My lord. Now may I read, my lord.
17.4. Yes.
Well, an arbitration committee shall be established to address any appeal to decisions taken by the IOA or any unresolved disputes arising within the IOA or amongst its members. Amongst members, the IGU is one of the members. The arbitration committee shall consist of 7 independent members whose membership shall be ratified by the IOA General Assembly upon proposal of the Executive Council. The arbitration committee shall include at least 4 members with a legal background, at least 3 members of each gender, and at least 1 athlete's representative elected by the IOA Athletes Commission. The powers, composition, and operation of the arbitration committee shall be regulated by a specific bylaw approved by the General Assembly. This is a composition. My Lord, may go to second flag mark. My Lord, if I straight come to 27.5.
Yes.
My Lord, it would be a mandatory for state sports associations to have all their disputes resolved through the aegis of arbitration commission set up by the Indian Olympic Association. Under no circumstances any of the state Olympic Association would resort to litigation in a court of law.
Any member of state Olympic Association would resort to litigation in a court of law.
Well, I'll come to it.
What does it mean?
Well,
you just read.
Upon no circumstances, any of the state Olympic Association would resort to litigation in a court of law. In the Constitution, it would be mandatory for state Olympic Association to include a provision that anyone going to the court, contrary to the provisions of the state Olympic Association, will entail sanction and disciplinary action. My Lord, my humble submission, my Lord, the writ petitioner is an affiliated member of the IGU. Now, the IGU is governed by this Olympic rules and regulation. Now, my humble contention is that any member affiliated to IGU is governed by this very provision. My Lord. Now, I will place the citation later. This is the background of the rules. If Your Lordship allow me to place the decision now about the maintainability.
Yes.
This to my friend. With Lordship permission, I will place the 13 decisions, my Lord, and compile it. My contention, my Lord, here is IGU is a registered society, registered under the Society Registration Act of Calcutta. Now, the issue whether, my Lord, Sports Federation, Lordship is very much aware, either PCCI, Football Association, Cricket Associations. The structure of the associations are, my Lord, international level is one thing, but in the country, there are 3 structures, my Lord. One is the national level, so-called the federation, like the IGU, Football Federation. Now, there's under that national.
You mean this IGU is like AIFF and.
My Lord, it's like a PCCI.
Federation and
yeah, like PCCI.
Same status.
Yes. PCCI is a state national federation. Now, under this national federation, state level association can be affiliated. Now, without affiliating to the national level, they cannot play. So, because of that, writ petitioner sought affiliation to my association. So, we have granted. Now, under the state level, there are district level associations also there. Now, district association level cannot come directly to the IGU and affiliate. They have to come under the umbrella of the state level. Now, under the state level, there are many district level associations, other associations are there, attached with the, or affiliated with the state level. Now, here we are not concerned with the district level. We are concerned with the relationship between the state level and the national level. Now, this state level has affiliated to me under the certain terms and conditions. That certain terms and conditions are authored by the IGU itself, not by the state, not by the other instrumentalities. Now, they know very well the position of that.
So the IGU has autonomy.
Autonomy.
Yeah, okay.
Autonomy, like BCCI and others, my Lord. Now, the issue arises, my Lord, how to test whether this type of sports federation would fall within the meaning of Article 12 of the Constitution, my Lord. May I just place a first citation with regard to that? The Pradeep Kumar Biswas case, my Lord. Page number 1. It's a 7-bench judgment.
Yes.
My Lord. 7-bench judgment 2002. Now may I come straight to page number 1 is the case, my Lord. May I come page number, my Lord, relevant paragraph would be paragraph 40. Page number
31.
Page number 30, my Lord. Page number 30. citing the other decisions of the Apex
Para
Court.
40.
Para 40, my lord.
Yes.
My lord. It says, my lord, the picture that ultimately emerges is that the tests formulated in Ajay Hasea are not a rigid set of principles, so that if a body falls within any one of them, it must, ex hypothesis, be considered to be a state within the meaning of Article 12. The question in each case would be whether, in the light of the cumulative effects as established, the body is financially, functionally, and administratively dominated by or under the control of the government. Such control must be particular to the body in question and must be pervasive. If this is found, then the body is a state within Article 12. On the other hand, when the control is merely regulatory, whether under statute or otherwise, it would not be served to make the body a state. Now, if I find here proper, my lord, Supreme Court has said that control should be pervasive, financially, functionally, and administratively. My lord, there is no financial control over the IGU. My humble submission, my lord. There is no functional control over the IGU, and administrative control is not there, my lord. Now, in view of this, my lord, the IGU is not, my lord, a state within Article 12.
So you say there's no pervasive control?
Yes, no pervasive control. No pervasive control, my lord. Now, the second decision may I refer is, my lord, page number 63, my lord. 63, my lord. Here, my lord, the Apex Court introduced the functional test, my lord. Page number 63, citation number 2, my lord.
Yes.
Well, now here, may I come to page number, my lord, 76. My lord. May I start from para 18. Para 18 and 32 and 33 may read out, my lord. Para 18. From the decisions referred to above, the position that emerges is that a writ petition under Article 226 of the Constitution there may be maintainable against the state government, number 2, an authority, a statutory body, an instrumentality or agency of the state, or a company which is financed and owned by the state, or a private body run substantially on state funding. A private body, this may be relevant for discussion, by a private body discharging public duty or positive obligation of public nature. And 7, a person or a body under liability to discharge any function under any statute to compel it to perform such a statutory function. Para 32 and 33 may come at this page number 86. 82. Merely because Reserve Bank of India lays the banking policy in the interest of the banking system or in the interest of monetary stability or sound economic growth, having due regard to the interests of the depositor, etc., as provided under sections and such of the banking regulation, does not mean that the private companies carrying on the business or commercial activity of banking discharge any public function or public duty. These are all regulatory measures applicable to those carrying on commercial activity in banking, and these companies are to act according to these provisions, failing which certain consequences follow as indicated in the Act itself. As to the provision regarding acquisition of a banking company by the government, it may be pointed out that any private property can be acquired by the government in public interest. It is now a judicially accepted norm that private interest has to give way to the public interest. If a private property is acquired in public interest, it does not mean that the party whose property is acquired is performing or discharging any function or duty of the public character, though it would be so far for acquiring the authority. 33 is relevant matter. For the discussion held above, in our opinion, a private company carrying on banking business as a scheduled bank cannot be termed as an institution or a company carrying on statutory or public duty. A private body or person may be amenable to registration only, it is important, where it may become necessary to compel such a body or association to enforce any statutory obligations or such obligation of public respect of a private company carrying on a commercial activity of banking. Merely regulatory provisions to ensure such activity carried on by private bodies who work within a discipline do not confer any such status upon the company or nor put any such application upon it, which may be enforced through issue of writ of under Article 226 of the Constitution. Present is a case of disciplinary action being taken against employee by the appellant bank. Respondent service with the bank service then terminated. Action of the bank was challenged by the respondent by filing a writ petition at 226 of the Constitution. The respondent is not trying to enforce any statutory duty on the bank, on the part of the bank. That being the position, the appeal deserves to be dismissed, my lord. Here in my case also, my humble submission, there is no such statutory duty casted upon the IGU, where the petition is seeking for enforcement, my lord. Now, another decision, third decision with lordship permission is page number 88, my lord. My lord, page number 88. Films Limited, my lord.
When was the IGU established?
IGU established, my lord, that lordship give me some time, my lord. I'll take a.
No, just want to know. How old is it? Anyway,
my lord,
yes,
my learned colleague from Delhi, my Mr. Heman will advise.
Z Telefilms.
Yes.
Yeah, page.
Now, the film, my lord, is a 5-bench judgment is important, where the Apex Court examined the functional tests of the PCCI, and the Apex Court came to a conclusion that some of the functions of the PCCI amounts to public function, not all. Not all. Now, this with regard to the, my lord, the fact of the case is with regard to cancellation of the contract of broadcasting of the PCCI cricket game. My lord. Now, with regard to this, may I take the relevant para, my lord? Lordship may mark it para 29, 30, 31, and 33.
29.
My lord, 29, 30, 31, and 33. My lord, my lord, we come to page number 120.
Yeah.
Page 120.
Then argued.
My lord. 29. It was then argued that the board discharges public duties which are in the nature of state functions. Elaborating on this argument, it was pointed out that the board select a team to represent India in international matches. The board makes rules that govern the activities of the cricket players, umpires, and other persons involved in the activities of cricket. These, according to the petitioner, are all in the nature of state functions, and an entity which discharges such a function can only be in the instrumentality of state. Therefore, the board falls within the definition of state for the purpose of Article 12. Assuming that the above-mentioned function of the board to amount to public duties or state function, the question for our consideration is, would this be sufficient to hold the board to be a state for the purpose of Article 12? Well, considering this aspect of the argument of the petitioner, it would be borne in mind that the state union has not chosen the board to perform these duties, nor has it legally authorized the board to carry out these functions under any law or agreement. It has chosen to leave the activities of the cricket to be controlled by the private bodies out of such bodies' own volition, self-arrogated. In such circumstances, when the actions of the board are not actions as an authorized representative of the state, can it be said that the board is discharging state function? The answer would be no. In the absence of any authorization, if a private body chooses to discharge any such function which is not prohibited by law, then it would be incorrect to hold that such action of the body would make it an instrumentality of state. The Union of India has tried to make out a case that the board discharges these functions because of the de facto recognition granted by it to the board under the guidelines framed by it. But the board has denied the same. In this regard, we must hold that the Union of India has failed to prove that there is any recognition by the Union of India under the guidelines framed by it, and that the board is discharging these functions on its own as an autonomous body. However, it is true that Union of India has been exercising certain control over the activities of the board in regard to organizing cricket matches and travel of Indian team abroad, as also granting a permission to allow the foreign teams to come to India. But this control over the activities of the board cannot be construed as an administrative control. At best, this is purely regulatory in nature, and the same, according to this court in Pradeep Kumar Biswal's case, is not a factor indicating a pervasive state control of the board. Be that as it may, cannot be denied, is important, my lord, that the board does discharge some duties, like the selection of an Indian cricket team, controlling the activities of the players and others involved in the game of cricket. These activities can be said to be akin to the public duties or state functions, and if there is any violation of any constitutional or statutory obligation or rights of other citizen, the aggrieved party may not have a relief by way of petition under Article 32. But that does not mean that the violator of such a right would go scot-free merely because it is or he is not a state. Under the Indian jurisprudence, there is always a just remedy for the violation of the right of a citizen. Though the remedy under Article 32 is not available, an aggrieved party can always seek a remedy under the ordinary course of law or by way of a petition under Article 226 of the Constitution, which is much wider than the such and such. My Lord. Now, in this court, in the case of such and such, has held that Article 226 confers wide powers on the High Court to issue writs in the nature of prerogative writs. This is a strict departure from the English law. Under Article 226, writ can be issued to any person or authority. The term authority used in the context must receive a liberal meaning, unlike the term in Article 12, which is relevant only for the purpose of enforcement of the fundamental rights under Article 32. Article 226 confers power on the High Courts to issue writs for enforcement of the fundamental rights as well as non-fundamental rights. The words any person or authority used in Article 226 are therefore not to be confined only to statutory authorities and instrumentalities of the state. They may cover any other person or body performing public duty. The form of the body discharge is not very much relevant. What is relevant is the nature of the duty imposed on the body. The duty must be judged in the light of positive obligation owned by the person or authority to the affected party, no matter by what means the duty is imposed. If a positive obligation exists, mandamus cannot be denied. Thus, it is clear that when a private body exercises its public functions, even if it is not a state, the aggrieved person has a remedy not only under the ordinary law, but also under the Constitution, by way of writ under Article 226. Therefore, merely because a non-government body exercises some public duty, that by itself would not suffice to make such body a state for the purpose of Article 12. In the instant case, the activities of the board do not come under the guidelines laid down by this court in such and such. Hence, there is no force in the contention. Now, by humble submission, my lord, here, Apex Court, my lord, will find that some of the activities of the PCCI.
So you're trying to segregate them public duties
yes,
with regard to players not, but other things, regulatory or statutory duties. You say they're total autonomous. Like IGU has got this autonomy, so like it doesn't come under the meaning of it will be amenable to jurisdiction.
Right. It clearly says that, but there should be a constitutional obligation or legal obligation.
Yes.
There is no constitutional obligation or legal obligation casted upon me, where petitioner can enforce. Number two, my lord, the rights of the citizens. The citizens is my lord, natural citizens. Here it is not the citizens are not approaching before this court. It is the society is approaching, my lord. Now, the next judgment, my lord.
Yes.
2015 SSC, my lord, where learned friend, my friend also relying upon. Page number 176, my lord. PCCI versus Cricket Association of Bihar, my lord. It's a 5-bench judgment. With regard to, my lord, the match fixings and frauds in the PCCI, my lord.
Yes.
Here, my lord, may I just take a lordship attention to page, my lord, para, my lord, para 33, 35, 34, and 35.
33, 34.
Okay. 33, 34, 35. And 11 page may proceed towards, my lord. Page 206, my lord.
Yes.
It refers to PCCI and Pradeep was in other cases, my lord. 33, my lord. The majority view thus favors the view that PCCI is amenable to the writ jurisdiction of the High Court under Article 226, even when it is not state within the meaning of Article 12. The rationale underlying that view, if we may say, with utmost respect, lies in the nature of duties and functions which PCCI performs. It is common ground that the respondent board has a complete sway over the game of cricket in this country. It regulates and controls the game to the exclusion of all others. It formulates rules, regulation, norms, and standards covering all aspects of the game. It enjoys the power of choosing the members of the national team and the umpires. It exercises the power of disqualifying players, which may at times put an end to the sporting career of a person. It spends crores of rupees on building and maintaining infrastructure like stadia, running of cricket academies, and supporting state association. It frames the pension schemes and income, expenditure on coaches, trainers, etc. It sells broadcast and telecast rights and collects admission fee to venues where matches are played. All these activities are undertaken with the tacit concurrence of the state government and the government of India, who are not only fully aware but supportive of the activities of the board. The state has not chosen to bring any law or taken any other step that would either deprive or dilute the board's monopoly in the field of cricket. On the contrary, the government of India has allowed the board to select the national team, which is then recognized by all concerned and applauded by the entire nation, including at times by the highest of all the dignitaries when they win tournaments and bring laurels home. Those distinguishing themselves in the international arena are conferred highest civilian awards like Bharat Ratna, such, apart from sporting awards instituted by the government. Such is the passion for this game in this country that cricketers are seen as icons by the youngers, middle-aged, and the all alike. Any organization or entity that has such pervasive control over the game and its affairs and such powers can make dreams end up in smoke or come true cannot be said to be undertaking any private activity. The functions of the board are clearly public functions, which till such time the state intervenes to take over the same, remain in the nature of public function, no matter discharged by a society registered under the Registration of Societies Act. Suffice it to say that if the government not only allows an autonomous or private body to discharge function, which it could be in any law take over or regulate, but even lends its assistance to such a non-government body to undertake such functions, which by their very nature
distinguish this from the case. Because in this they said it's amenable.
Yes, my lord. Here in this case, the issue involved is the match fixings and frauds. Therefore, the apex court say that this really affects the larger public interest. Therefore, writ is amenable. Though BCCI is not a state, my lord. In the IGU case, this ramification is not at all there.
Next judgment.
My next judgment, may I travel to, my lord, page number 200, my lord, 25, my lord.
Yes. St. Mary's.
St. Mary's, my lord. Is a recent, my lord. It's a examining the entire, my lord, legal issue. Relevant para, my lord, may take two. Para 37 and 41, relating public law and private law, my lord. 37 and 41. Page number 83, my lord.
83, yes.
83, para 37.
This court in KK Saxena.
My lord, this court in the case Saxena and other International Commission on Irrigation and Drainage, after exhaustive review of its earlier decision on the subject, held as follows. What follows from a minute and careful reading of the aforesaid judgment of this court is that if a person or authority is state within the meaning of Article 12 of the Constitution, admittedly a writ petition would lie against such a person or body. However, we may add that even in such cases, writ would not lie to enforce private law rights. There are catena of the judgments on this aspect, and it is not necessary to refer to all those judgments, as that is the basic principle of judicial review of the action under the administrative law. The reason is obvious. A private law is that a part of a legal system which is a part of common law that involves relationship between individuals, such as the law of contract or torts. Therefore, even if writ petition would be maintainable against an authority, what is state under Article 12 of the Constitution, before issuing any writ, particularly writ of mandamus, the court has to satisfy that action of such an authority which is challenged is in the domain of public law as distinguished from private law. In my humble submission, my lord, the MOA and RR, my lord, it is framed within the realm of private law. It's not it doesn't involve any public law, my lord, public law. And the relevant, another para is 41, my lord. It is more clear, my lord. Yes. Para 41, my lord. It says, my lord, this court consider various of its other decisions to examine the question of public law remedy under Article 226 of the Constitution. This court observed in such and such a case, my lord. Thus, it can be seen that the writ of mandamus or the remedy under Article 226 is preeminently a public law remedy, is not generally available as a remedy against private wrongs. It is used for enforcement of various rights of the public or to compel the public statutory authorities to discharge their duties and to act within their bounds. It may be used to do justice when there is wrongful exercise of power or refusal to perform duties. This writ is admirably equipped to serve as judicial control of administrative action. This writ would also be used against any private body or person, especially in view of the words used in Article 226 of the Constitution. However, the scope of mandamus is limited to enforcement of public duty. The scope of mandamus is determined by the nature of the duty to be enforced, rather than the entity of the authority against whom it is sought. If the private body is discharging a public function, and the denial of any right is in connection with the public duty imposed on such body, the public law remedy would be enforced. The duty cast on the public body may either be statutory or otherwise, and the source of power, such power is immaterial, but nevertheless there must be the public law element of such action. Sometimes it is difficult to distinguish between public law and private law, my lord. Now, just one more para. Yes, that is one, my lord. Now, in my humble submission with this, my lord, here the IGU, the status of the IGU is purely, my lord, is private.
Private law.
Yes, and RR and the MOE is standing within the realm of a private law, my lord. No public character is involved, no public element is involved, my lord.
Yeah.
Another judgment may take to page number 306, my lord. My lord.
Yes.
Relevant para would be Lordship Megality para 16. Page number, my lord, 314.
Yes.
314. It says, my lord, learned senior counsel further placed reliance upon the decision of the High Court of Delhi in such and such, wherein learned single judge arrived at the same conclusion while dealing with the writ petition filed against the Bharat Aluminum Company Limited in the year such and such, and decided in 2008 the sports privatization of the Balco in 2001. Relevant portions from the said judgment as relied upon are extracted here and below. It is fairly well established that the writ petition is not maintainable against a private limited company or a public limited company in which the state does not exercise all pervasive control. In such 2005, the Supreme Court has held that the writ petition under Article 226 of the Constitution is normally issued against public authorities. It can also be issued against private authorities when they are discharging public function, and the decision which is sought to be corrected or enforced must be in the discharge of public function. In the present case, the issue and question involved do not relate to public function. It's a dismissal of the case, my lord. Here, in my humble submission, my lord, here also, that the public duty is not involved when the IGU performs its duties, and especially when it comes to affiliation, disaffiliation, it is purely contractual in nature. And the Apex Court, my lord, read with the St. Mary's, read with the KK Saxena case. Supreme Court is very clear. Even all the action of the public authorities, so-called the state, are not amenable to restriction. It depends on the nature of the action, my lord. Now here, Lordship may kindly examine the nature of the...
So you say one thing, that the action of, de-affiliating them,
yes,
without giving an opportunity, that not...
my lord.
That not, that
yes,
they cannot invoke 226.
My lord,
even the breaching of national justice,
yes,
they'll have to go by the arbitration that have not been heard, and summarily they were affiliated, and after some time, just with that letter, they came to know they did not meet the requisites, and they were de-affiliated.
Right.
So that is perfectly all right.
My humble submission is, my lord, though I not agree with that there was no notice issued to him. Notice was issued to him, he denied that one. He denied it doesn't amount to.
Anything else that is more...
yes, I'll come to that, my lord, whether affiliation or disaffiliation amounts to public function or not.
Exactly,
I'll come to that
yes.
judgment. That is the crux of the matter.
Point,
yes. Now the interpretation, the law evolved, is reaching to a stage that the functional test is very important.
Yes.
Now the structurally, PCCI doesn't fall within the meaning of Article 12. But IGU also will not fall. Now Supreme Court said that the functional test, when we introduce a functional test, some of the functions of the PCCI fall within the public function.
Realm of public.
Realm of public. Yes. Now, in my case also, my lordship may kindly examine whether the affiliation falls within the public function or not. That's the matter. I would.
So it will settle on the functional test.
Yes.
Of the action of the IGU.
Yes.
In the de-affiliation.
Yes.
Whether it will meet the will come within the meaning of public law and the realm of public law.
Yes, yes.
And your
right, right. And once the petitioner established that it falls within the public function, then he can claim the principle of natural justice and others. But now my humble submission is that, my lord, the affiliation do not fall within the purview of public function. My lord. May I come to page number, my lord, 325.1. My lord. Is a, my lord, division bench judgment of the Mumbai High Court. Where,
Mumbai High Court.
With yes, cricket association involved. My lord.
Yes.
As a persuasive judgment, my lord, I'm placing page 325.1. My lord. Relevant para may take relevant para, my lord, 26, 31, 33, and 45.
26, 41,
33, and 45. And may take lordship attention
26, 31.
Yes. 26, 31, 33, and 45. So may lordship kindly come to page number 325.11.
Yes.
Para 26. It refers to Supreme Court. Well, the Supreme Court in para 11, such Zee Telefilm Union of India has observed that some of the activities of the board may be akin to public duties or state functions, and if there is a violation of any constitutional or statutory obligation or rights of any citizens, the aggrieved party may not have a relief by way of petition under Article 12, but that does not mean that the violator of such a right would go scot-free merely because it or he is not a state, and remedy may lie under the ordinary course of law or by way of a writ petition under 226 of the Constitution, which is wider than Article 42. Having said so, it is incumbent upon the original petitioner, present respondent, to show any constitutional or statutory obligation which has been infringed in order to enable him to invoke extraordinary powers of this court under Article 226. In the absence of the same, it is difficult to maintain a petition as being unable to seek redressal of the grievance against the Vidarbha Cricket Association to invoke extraordinary powers and jurisdiction of the court under Article 226 of the Constitution. My lord, may I go to my lord 31 to save lordship.
Yes.
May start 30 also, my lord. Para 30, page number 325.15. Page number.
Yes.
My lord. It would be pertinent to note that the Apex Court appears to have cautiously expressed that some of the activities like selection of team cricket, controlling the activities of players and others involved in the game to be akin to public duties or state function, indicating that the Apex Court did not intend to hold all the activities to be public duties. As such, it has to be appreciated that while the majority view had said that some of the activities may be akin to public duties, and yet it had refrained from referring to all the activities of the board to be public activities and or duties, sufficiently indicating that not all the activities of the board are public duties. Having regard to aforesaid, the decision to make ex gratia payment to ex-Ranji Trophy players had been voluntary and not under discharge of any public function or duty, nor under any statutory or constitutional obligation, nor the same would be claimed by the original petitioner as a matter of right. The alleged monopolistic role in the field of cricket game by Such within its territorial region does not accord such activities public duty status. The fact that the activities being carried out by the VCA being voluntary in nature and not controlled by any statutory obligation measured by the state, the action of the VCA in causing interruption in ex gratia payment to the original petitioner being not in breach of any statutory measure, nor that it is an obligation under any statutory or constitutional provision, the action of the society being within its domain cannot be said to be in discharge of any public function or duty. So my humble submission, my lord, here also the Learned Division Bench of Mumbai High Court, withholding of the ex gratia payment to the cricket players do not fall within the meaning of public domain, but is purely a private, is a contractual in nature. Now may I proceed further, coming closer to the point of the affiliation. Lordship,
yes,
kindly come to.
Now you've
Yes.
You've placed a decision regarding this.
Yes.
But now what about affiliation and
my lord? Affiliation, my lord, I would place the three decisions of the Kerala High Court division and single bench.
Kerala High Court,
my lord, where it relates to affiliation, my lord. Affiliation. My lord may come to page number 378.
378.
My lord. It is regard to Kerala Roller Skating Association.
This is on affiliation.
It is related to affiliation also. Affiliation is one of the issues. And formation of the ad hoc committee while suspending the other association, that was one of the issues. In Kerala, the state legislation is there. But with regard to formation of the committee, the statute controls. But with regard to affiliation and the affiliation is purely within the confines of the...
court wants to examine, yes.
Yes.
Which one you referring?
Page number 378.
Yes.
My lord. Is it, my lord?
Yes.
Is the division bench judgment 2014. Relevant para, my lord, may mark it, my lord. Para 9, 10, 17, 18, 19, and 22, my lord. Relevant page will be, my lord, 400.
This is writ appeal.
Is a writ appeal. It's
No.
a writ appeal.
It starts on 382.
378.
378.
378.
378, there's a cause title, Melody,
Yes.
and thereafter the judgment follows.
378.
It's on a
Oh,
different type.
there are different fonts.
Yes.
Right, that's what it is. Okay.
Well, and
kindly come.
My lord may come to relevant para, my lord. Para 9 onward. That is page number 392. Para 9, my lord. My lord, the first issue to be answered is as to the maintainability of the writ petition. From the relief as quoted above and claimed by the petitioner, it is clear that the relief is in two parts. The first relief claim was a mandamus directing and compelling the Ernakulam District Sports Council to restrain the ad hoc committee from functioning in the Ernakulam district, and further declaration that the players selected by the petitioner as per such be permitted to participate in the State Roller Skating Championship 2014. Second part of the prayer is to declare Exhibit 15 and 16, which are the order disaffiliating the petitioner and appointing the ad hoc committee illegal. Which is important with two issues. Scope and ambit of Article 2 to 6 of the Constitution of India has come up for consideration before the Apex Court in the large number of cases. Writ petition is maintainable against any action of the state or any authority within the meaning of Article 12. There is neither any foundation nor basis to hold that respondent number 5, that the state association is covered as stated within the meaning of Article 12. The state association is an association registered under the Such Act and is affiliated with the National Roller Skating Federation Association of India. It is governed by the rules and regulations registered under the Act of Such. State legislation has enacted the Kerala Sports Act 2000 to provide for the promotion of sports and games and to augment the athletic efficiency in the state of Kerala, and for the constitution of sports council at the state level, district level and local level, and for matters ancillary or incidental thereto. Under Section 3, the State Sports Council has been constituted. Similarly, Section 9 provides for constitution of District Sports Council. Sports organization has been defined in such matter. Now, may I come further to straight away go to next page, para 12. At the bottom, rules and regulation of the State Association provides for membership in Clause 6, which is quoted as below. Membership. There may be only 3 categories of members of the general body. Affiliated district level roller skating association. Founder member existing 2 members only. Founder members shall hereafter be elected to the executive committee of the association and invitees. Bylaw 7 deals with the categories of membership. Clause A defines a founder membership, whereas Clause B relates to affiliated district skating association. Madam, may I go to page number para 17. Yes. 17. Regulation 73C contains the terms and conditions which provides that the state and district teams shall be selected by the selection committee formed by the association in accordance with the direction given in Chapter 9 of the regulation and the guidelines issued by the Kerala Sports Council from time to time. Since one of the issues pertains to selection of district team, the above provision, which is statutory provision, becomes relevant. The above provision also thus regulates selection of district team. Hence, selection of district team being regulated by the statutory regulation can very well be made subject of challenge in a writ petition under 226. It is well settled that any action which is in breach of the statutory provision can be made subject to writ petition under Article 226 of the Constitution, and this court can very well issue a mandamus regarding the action which has been taken in violation of the statutory provision. From the above, it is absolutely clear that insofar as selection of the district team for state championship, which is regulated by statutory provisions, can very well be made subject matter of judicial review under Article 226 of the Constitution. An update up to that extent, the writ petition is fully maintainable. Action of selecting district team for the state championship falls in the domain of public function and very well can be made subject matter of issue in a writ petition. It shall suffice to refer to the judgment of the Apex Court in such and such, where it was held that public law remedies available against private party, wherein such private party charged for public function matter. I may not repeat again. Now, my lord, may comes to page number 408, para 19, my lord. 408, para 19. Para 19, my lord. 408. Para 19, my lord.
Yes.
My lord. When function entrusted to a private party is regulated by a statute, and the party is obliged to perform the function, the said function is in the nature of and character of public function, which can be made subject matter of an issue of writ proceeding. Thus, to the above extent, the writ petition which sought relief in the context of selection of a district team to participate in the state championship, the writ petition is solely maintainable. Now, may I come to the next page, page 110, para 22, my lord, is relevant, my lord. With regard to second issue, my lord, it is. Now, we come to the appeal filed by the district association. In the writ petition, one of the relief is sought to quash Exhibit 15 and 16 letter they censored by the issued by respondent number 5, disaffiliating the petitioner and appointing an ad hoc committee. Insofar as the orders and such by which petitioner membership was terminated, disaffiliated, the said decision was taken by respondent number 5 in the exercise of its power under the rules and regulation of which are non-statutory in character. The said action of respondent number 5 cannot be treated to be one within the domain of public function, as has been rightly refused to entertain by the learned single judge in his order in sunset. We fully endorse the aforesaid view of the learned single judge. In challenging the action, the remedy of the petitioner is to approach the civil court or to take such a remedy as permissible under the law, my lord. So it is very clear, this issue, my lord. Issue.
De-affiliating.
Yes, de-affiliating is, my lord.
Is it called de-affiliating or disaffiliating?
Disaffiliation.
It will be disaffiliation, not de-affiliation.
De-affiliation.
Now, with regard to other one, my lord, we come to the next decision. These two, my lord, division bench order, same order, my lord. Page number 413.
Same bench only.
Well, the same bench. This would be Kerala Cycle Polo Association case.
This is cycling.
My lord. Page number 413, lordship, can you see?
Same judgment was passed.
Yes, my lord. Relevant para may take, my lord. Para 15, 17, and 19.
Okay.
(15, 17, and 19). My lord, may come to page number 428.
Yes.
428. Para 15, my lord. 428.
Para 14?
Para, my lord. Para 14, shall I read, my lord?
15, you saying?
15, my lord. Para 15.
Yes.
As far as the relief sought for the writ petition are concerned, on account of subsequent events, the writ petition have virtually become infructuous. The challenge by the petition WPC was formation of an ad hoc committee by such. In fact, no ad hoc committee can be formed to replace KPCA. Whether an ad hoc committee can be formed to replace KPCA in the matter relating to sporting event of cycle polo virtually depends on the terms of contract or rules under which KPCA affiliated to the National Federation. However, formation of ad hoc committee has now lost its relevance on account of subsequent events by which National Federation has disaffiliated KPCA. Whether this qualification is proper or not, under the factual circumstances involved in the matter, are not matters which are to be settled by this court in a proceeding under Article 226 of the Constitution. We have already taken a decision that the judgment such after having considered PCCI case, and in that so far as selection of the teams for participating in the championship is a function which is regulated by provision, the writ petition remains enabled to that extent. Relevant portion, I will not. May come to 17, my lord, next page. In the such circumstances, we have to consider view that KPCA will have to challenge the action of National Federation in disaffiliating them in appropriate proceedings, which cannot be decided by this court in this appeal, as the said subject matter involved is substantially different. Now, the next page 19, my lord. In page number 432, the last one.
Yes.
Insofar as the WPC is concerned, the cited petition is seeking the various grants payable by the Kerala Sports Council. In fact, it is for the Sports Council to decide the claim based on the eligibility of petitioner, for which they have already given certain representation in Exhibit Sunset. We only direct Kerala State Sports Council to consider Exhibit B 6 and 7 in accordance with the procedures prescribed. Taking into consideration the above overall facts and circumstances involved in the matter, upon these circumstances, the aforesaid cases are disposed of as under. WPM such are disposed of with the liberty to the appellants to approach the appropriate forum to challenge their disaffiliation. Other contentions are left open to be decided in the appropriate forum. So, disaffiliation matter, it is beyond the scope of Article 226. Another judgment relating to disaffiliation, the last one, is single bench 2015, passed on 10 April.
Kerala again.
Kerala again, my lord. Page number, my lord, become 436.
Yes.
This was passed on 10 April 2025, recently, my lord.
10 April 25, okay.
My lord. 400, page number 436.
Yes, got it. Paras?
Relevant para, my lord, may kindly mark para 8.1 to 8.6.
8.1 to 8.6.
My lord. Yes. That is available. This was a purely disqualification case.
Yeah.
Disaffiliation. My lord, may kindly come to page 453. On the top, para 7, my lord, the point frame. Following points arise for consideration in this writ petition. Can the writ be issued under Article 226 of the Constitution against the National Federation in the facts and circumstances of the case at hand? Para 7, 8, my lord. The first issue rising for consideration, as noticed earlier, is with regard to the maintainability of writ petition. The issue arises for consideration especially in the light of the prayers in WPC, which are as under. Issue a writ in the nature of mandamus commanding the respondent before to grant affiliation, renewal to the petitioner association at the earliest, duly taking into account Exhibit Sunset. Issue a writ in the nature of mandamus commanding the respondent to disaffiliate the respondent number 7. Number 5, madam. Madam, I may skip that 8.4, 8.1. I may straight away go, madam, to save lordship time. It has referred to PCCI case. And my lord may come straight away to page number 459. Para 8.4. It is also to be noted that though the KPCA challenged the judgment of the division bench referred to above by filing SLP since 2016 by an order dated such, the apex court disposed of the same as under. Mr. P.S. Naramsa, learned ASG, appearing for the Union of India, states that Cycle Poro Federation of India, against whom the relief has been sought by the Petition Association, has itself been disaffiliated. In view of this development, the relief sought in the special leave petition cannot be granted. It is made clear that above order will not stand in the way of the Petition Association for seeking any other relief in accordance with law. This special leave petition is accordingly disposed of. In the light of the aforesaid, that question is that formulated above is to be appreciated. This court notices from all the above fact. My lord, number 2 in Mekam. The disaffiliation by the National Federation.
Okay.
Yes,
the affiliation disaffiliation is verified.
Yes, with reference to their memorandum of association. In the light of the aforesaid, no writ can be issued against the National Federation, especially with reference to the disaffiliation of a state association by the National Federation. It is for KPCA to ven out its grievance in accordance with the law. Therefore, I am of the opinion that it is for the KPCA to challenge the disaffiliation in accordance with the law before the appropriate forum, as held by the various benches of this court as well as the apex court. It also takes note of the judgment rendered by the learned single judge in this court, such and such, as per which the court held that challenge against disaffiliation of association by the state association is not maintainable, and that the party has to approach the competent civil court. Therefore, I hold that KPCA would not be entitled to maintain WPC in the light of the aforesaid. I'm of the opinion that the mere reference to the order issued by the State Sports Council as affirmed by the Appellate Tribunal is also not going to make any difference as regards the maintainability of the petition in view of the aforesaid discussion, my lord. So my humble submission here also affiliation issue is purely contractual in nature within private realm. Writ court jurisdiction will not cover that one. Now this is with regard to that structural test and functional test, my lord. In brief,
submission is that they were given notice regard to the pending disaffiliation.
Yes, my lord, that with regard to it is an annual up-to-date information from all the associations. So when we issue notice to the petitioner also, not only to him, many associations. In response to that, many associations responded, updated themselves. Petition did not respond at all, yearly basis. And the affidavit they have annexed some documents, that is the previous years.
So there's no sort of a special exercise. It's just that it's an annual audit is done, which associations are functioning or they are complying with the directives of whatever holding tournaments, yes. All these kind of things. And what is the how do they how was it exercised? I mean, okay, the IGU is the apex body, yes. under the Indian Olympic Association, right. Recognized for as the national federation to recognize and affiliate these other golf clubs or golf associations with them. Right. Now that means they undertake a yearly exercise of all the golf associations as whether they are functioning,
yes.
In a proper manner. Yes. That is all.
My lord, it's a yearly exercise to ensure that all the affiliated state associations are functioning in adherence to the MOA and the RRs. My lord. And whoever not fulfill, my lord, they are dismembered from the IGU, my lord. And the last regarding this point, the issue functional test, the last decision may refer page number 488. 488. This is passed by the Telangana High Court by single bench with regard to calling up the exit committee, meeting of the Sports Association, Olympic Association.
488.
My lord, page number 488. And my lord, may I take the relevant para 16, 18, 19, and 23. And my lord may come to page number 501 onwards.
Yes.
My lord, para 16.
Yes.
My lord, married. In the light of the law laid down by the Honorable Apex Supreme Court in Ramana Shetty, it is to be noted that in the instant case, the President and members of the Second Respondent Association are neither nominated or appointed by the state government, nor the Second Respondent Association is required under any act passed by the Parliament or the state legislature to submit its program of activities and financial estimates, nor the Respondent number 2 can carry out only such activities and incur only such expenditure as is approved by the state government. Further, Respondent number 2 audited accounts together with the audit report is not required to be laid before the houses of state legislature. Therefore, Respondent number 2 does not qualify to be an instrumentality of the state under such. Further, my lord, I'll quote, and my lord, I'll come to 18, my lord. Though it is contended that Respondent number 2 Respondent Association received funds from Olympic Association and state government and others, it is to be noted that neither the powers to conduct the day-to-day business and affairs of the Second Respondent Association flow from any authority bestowed by the government, so as to imply that the government is executing its work through Respondent number 2 as an instrumentality of state.
Become a pervasive control only.
No pervasive control. Number 90. In view of the foregoing, it cannot be said that Respondent number 2 Association is instrumentality of the state as to maintain a writ petition under Article 26 of the Constitution. The Respondent number 2 Association is only entity registered under the Society Registration Act 2001. In case of dispute amongst the members of the association or any other matter relating to affairs of the association, the dispute resolution mechanism provided under Section 23 of the Act is appropriate recourse to the petitioner. Now, Section 23 is provided there. Dispute regarding management. In the event of any dispute arising from the committee or the members of the society in respect of any matter relating to affairs of the society, any member of society may proceed with the dispute under the provision of Arbitration and Conciliation Act, such and such. Well, so provisions provided, madam. Now, 21, to elucidate further as to whether the election dispute comes under the phrase any matter relating to affairs of the society, it would be relevant to refer to such and such, wherein the High Court as follows. The expression any dispute is wide enough to cover any disputes relating to election of the members of the committee. So any dispute rising among the committee, albeit it be a dispute pertaining to election of the office bearers of the committee, squarely falls within the expression any matter relating to affairs of the society, as has been used in sections and such. The expression any dispute in any matter relating to affairs of society are too wide enough even to cover the election dispute relating to election of the office bearers of the committee or any other relating to the affairs of society. Even election of the office bearers of the committee relates to affairs of the society. The Honorable Division Bench of this court and such held that upheld that the petition against society is not maintained by SS, it does not fall under such. According to the writ petition disposal, leaving open the petitioner to avail the remedies available. In my humble submission, in my RR, any unresolved disputes.
So that it'll cover all these kind of disputes also.
This affiliation, imposing penalty, these are the it's purely contractual relationship between the national federation and the state federation. There is
how many years was this? Was this Shillong promoters? What's called?
All promoters.
How many years was affiliated?
9 years plus.
2021.
Continuously.
2021.
And before that, SGA.
No.
SGA was never there.
SGA was not part of that.
SGA was a defunct body which has been revived some 3 years back. SGA has been a defunct body.
SGA was not affiliated. They don't apply to me also. So there is no question of affiliation.
So God promoters the only association that was affiliated, right?
Now,
yes,
my lord, other low points, my lord. I'll just place two judgments and I'll conclude my submission, my lord. These are the functional tests, my lord. According to me, the writ is not maintainable. The issue, my lord, with regard to alternative remedy, my lord. My lord, I cite one judgment of the Supreme Court, my lord, that is page number 326 of the same compilation. 326.
This is the point of
the compilation. The compilation.
On the
point of the arbitration mechanism provided in the between the parties.
Okay.
Writ court would, my lord.
Justice technologies.
My lord.
Yes.
This is 2015, my lord. Revision para, my lord. Para 69 and 69.2.
Yes.
My lord may come to page number 373. My lord, 373. My lord, though I am not admitted, but for the sake of argument, assuming that writ lies before my lord, still my second leg of my submission is this, that in view of the arbitration provision, writ would not be, my lord, 69.
When
the position, my lord, we start from 61. The position that's summarized in the aforesaid principle as to be understood in the context of discussion that preceded, which we have pointed out above. As per this, no doubt, there is no absolute bar of the maintainability of writ petition even in contractual matters, or where there are disputed question of fact, or even when the monetary claim is raised. At the same time, discretion lies with the High Court, which under certain circumstances it can refuse to exercise. It also follows that under the following circumstances, normally the court would not exercise such a discretion. The court may not examine the issue unless the action has public law character attached to it. In my case, this affiliation, there is no public character. Whenever a particular mode of settlement of dispute is provided in the contract, the High Court would refuse to exercise its discretion under Article 226 of the Constitution and relegate the party to the said mode of settlement, particularly when settlement of dispute is to resort to through the means of arbitration. But squarely, my case fall within these parameters of law. And the last judgment may I place, my lord, as the last leg, page 505, 506, the last judgment, my lord.
This is also alternate dispute.
Yes, my lord. My lord.
Alternate remedy, sorry.
My lord. And may I refer to relevant para 14.
Yes.
My lord.
Principle of waiver.
Waiver. The principle of waiver connotes issuance of notice and non-response thereto. Everyone has a right to waive an advantage or protection which law seeks to give him or her. Undoubtedly, if a notice is issued and no representation was made by either the owner, tenant, or the subtenant, it would amount to waive the opportunity, and such a person cannot be permitted to turn around and after the scheme reaches finality to say that there is non-compliance of the such. It would amount to paying premium on dilatory and dishonest conduct. Only my lord would point, RR 66 clearly spell out that when you come for affiliation, you have to give up. You should not approach before the court of law. Because the arbitration mechanism is provided. The basic purpose, in short, my lord, why the arbitration mechanism provided? Because the sports is aiming to promote the sports activities. Yes. Otherwise, my lord, the affiliated society will entangle with litigation one after another and discourage the spirited sports person in the country. Therefore, the attempt was made to resolve any disputes within the four walls of the federation itself. So party has to approach this. So my humble submission is that writ is not maintained.
Yes. Anyone wants to add to the submission?
I am adopting.
Dr. Mozika, you're supporting or?
Small submission. Do I have a formal party?
You're appealing for whom? Indian Olympic Association. Why India is here?
Union of India governs Malaya's Ministry of Sports. IGU is receiving grants from them. Even though on affidavit they've stated they don't receive any money.
Who has said? On affidavit?
IGU, Malad. I'll take your lordships.
Yes.
But I don't have any submission to make on maintainability or alternative remedy, my lord. My only concern, my lord, if I take lordship to the rules, my lord, annexed at page 45 of the writ petition, my lord.
Page 45.
Page 45, my lord. They profess to be governed by these rules, my lord, the Indian Golf Union. Now, what is golf club, my lord? What is state golf association? So, in my humble submission, these are slightly relevant, my lord. Clause N at page 46, lords, you kindly see, my lord. State golf association means the state golf association of any state, union, territory, or in India, which is affiliated to the Indian Golf Union. Now, the golf club, my lord, the first clause A.
Golf club, yes.
It means any entity, whether owned by an individual, association, or person, so and so, that is affiliated to the Indian Golf Union or seeking affiliation to the union having a functioning golf course and as defined in clause 5. Now, my lord, what is concerning, my lord, page 49, lords. My lord, what is my submission, my lord? The IGU is an affiliating body, my lord, and it is not expected to jump into the arena, my lord.
Jump into what arena?
Arena when there is a dispute or fight between several so-called sports associations, my lord. That is relevant because, my lord, page 49, clause 3, my lord, lordship says, election to the managing committee office bearers of state golf association, my lord.
Yes.
A. The SGA will follow election bylaws of the model election guidelines as given in annexure so and so. Following aspects must be complied with. An electoral college shall be formed from amongst the IGU affiliated golf courses within the state. Wherever election is required for any post, the same will be decided by a secret ballot. Timelines for nominating, filing, withdrawal of nomination, etc. and declaration so and so shall be adhered to. Clause B, my lord, to ensure true representativeness in keeping with the number of golf courses that are recognized in a state. The election of the managing committee of the SGA will be regulated as under: SGA with 1 golf course, SGA with 2 golf course, 3 golf course and more golf courses, my lord. So now, my lord, it is for the golf clubs to form an association, and it is for IGU to affiliate that association, my lord. It is not for IGU to select from amongst the many golf associations, my lord. That is my case, my lord.
So your case is that there might be 2-3 associations, they can't all be affiliated.
Well, what I am trying to say,
but affiliations limited to only 1 per state. That means
yes.
Is that by?
Yes, my lord. And that association is to be.
One case you are doing, so Paul, karate thing is not your case. So some time back.
Karate is different.
There was a dispute in Shillong with taekwondo.
Karate is different, Malaj. I'm aware of that. Karate is different. Here, Malaj, it has to be one state. It has to be one state association.
So, my lord, in my humble submission,
they were both recognized.
There is different, Malaj.
The style of karate. No, that is what.
Different schools, my lords, maybe.
Okay.
So, my lord, what it appears that what is the State Golf Association, my lord? That is to be a representative body to be elected by the golf courses, my lord. Now, it appears, my lord, neither Mr. Paul's club is constituted in that fashion, my lord, nor Mr. Nongre's.
So what you're submitting is that if you have to have a real golf association, all the golfers of the state,
my lord,
they have to
golf
have
clubs,
the golf club or golf. I mean,
my lord, there has to be a college. There has to be a college kind of thing, my lord.
Then they vote.
They'll elect a
They'll look a body
and
to be there, like
an IGL
like a lawyers association.
My lord.
Or lawyers of the state, they have the
my lord.
bar association.
My lord.
That's going beyond the brief, I think. Yes.
Well, of course, they have gone on a different tangent, my lord, but this appears to be the correct position, my lord.
Interesting. Yes. Yes, what do you have to say? So, is that correct what Dr. Mozika says? That
well, it's even assuming what
any association,
well, it's assuming
all the golfers of the state.
If what my learned friend is saying is correct, my lords, I'll just take to one set of annexures in my rejoinder affidavit.
Just listen.
No,
what he's saying is that all the golfers,
golf clubs will decide, my lords, who will be the state association.
No, all the golfers who play in Shillong Golf Course, they will form.
Not only golf course, my lords, all golf courses in the state.
In the state,
so
yes.
There are 4 or 5 golf courses.
7.
So all of them all the players will make an association.
No, my lords. Then they will decide which is going to be the golf. Which is going to be the golf association?
For Meghalaya.
Exactly, they will form. I mean, like it will be an open election, right, to all the golf players.
Because then there will be different golf clubs, and the different golf clubs
and
will then
that
represent
depends. All of golf club, the association will be
association.
Like a parent body.
So there's no question of multiple golf associations, my lord. There can only be one.
Even assuming, my lords, what my learned friend is saying is correct.
If it is elected that way,
I have the support of all these golf clubs, and we've annexed the letters, my lords, before your lordships.
So in my humble submission, let there be a floor test kind of something
like
a floor
test. That floor test is not required, my lords, because the letters of support are here with us, and that's not being disputed. I'll take your lordships to that, even though that's not the issue at hand. The issue at hand is a little more complicated than
going to brief now in the issue maintainability. But then what Dr. Mozika has.
I have annexed the letters of support of all the golf clubs of Shillong, my lords, save Shillong Golf Association.
In my humble submission, whether your lordship will accept those letters of recommendation or letters of support.
No, that is.
That's not the issue here.
So let there be a floor test, my lord, and IG is
bound. This is taking it to another level, my lords. That the first question is, my lords, that there is no dispute that I was the only affiliated body. SGA was never affiliated, my lords. It has been candidly submitted before lordships. They make an entry in 2025. Till 2023, they were a defunct body.
You have to create a level playing field, make a new body.
Well, bodies will come and bodies will go. It's not a question of bodies. I would slightly disagree from whatever has been submitted before lordships. We'll try and satisfy your lordships on the issue.
We're looking at this anyway. That's just
once my friend finishes,
that's just a roving opinion. It's not a question. It's a question of looking at the larger interest. Suppose one thing, Mr. Paul. Suppose the affiliation is given to you only. That means the other golfers who are like members of this Shillong Golf, they can't put us of selection to any national tournament.
No, my lords, they are all.
That means
only from my lords, it's nothing like that. It's nothing like that, my lords. If I may, what happens is
that is the impression that the school is having.
No.
That suppose
it's not like that. We have as a matter
only your players.
No, my lords. As a matter of fact, we can furnish the list of the people who have been playing in the Shillong Golf Club, my lords, who have been recommended by us, who have gone on to play national tournaments, international tournaments.
Not member of golf promoters.
No. It is just a society which is helping, my lords, in augmenting the resources and ensuring, my lords, there is proper representation of the players from Meghalaya to different thing. It does not regulate anything. I cannot stop anybody.
Does that mean that your lesser members?
I am only promoting my people or people from my clubs, my lords, nothing like that. Anybody, as a matter of fact, that list I have given, my lords, on the last date, your lordships will see these are local boys who are playing in the Shillong Golf Course, which apparently belongs to respondent number 5, they claim.
This is just from common knowledge. It has happened in cases where, suppose, coming out to other disciplines, where a boxer, that's your case only, who's not a member of, he's an army boxer. He went for selections, he was not given, he was given short shrift.
Here, my lords.
Because this recognized body wanted to promote their own boxers. So he was an army boxer.
In this case, my lords, the people from Shillong Golf Club they've gone on to play national tournaments and international tournaments. I can give the list.
Golf is on the basis of ranking. It's not on
I cannot stop anybody.
It's based on ranking.
So this affiliation, de-affiliation, my lords, it has nothing to do with the golfers. My lords. As a matter of fact, we are only here to help whoever are the golfers in the state.
Let's hear Maintainability before we go to other things.
Well, only one aspect, my lord. So, in that view, in view of the rules of the IGU itself, my lord, the State Golf Association cannot be property of a particular Shillong club, or it has to be a representative body, to representative of all the golf clubs in the state, my lord.
Has to be everybody.
That it is.
The correct interpretation of Rule 3, my lord, is when a golf association is affiliated, my lord, how the elections are to be held within that association. That is the interpretation of
Exactly. That does not deal with, my lords, a larger situation as was expounded by my learned friend.
That's the interpretation of
It just wasn't, of course, all the golfers in the state. He's saying all of them.
It's not like that, my lords. What happens is, if I may, it's a hierarchy. Just, my lords, I must place it before lordships how it works. It's a hierarchy. At the top, we have the IGU, which is then, my lords, directly in contact with the Government of India and the Ministry of Sports and the Indian Olympic Association. Olympic Association with regard to all sports. Golf, IGU is specifically with regard to golf. So that's the hierarchy. Below that, we have the State Golf Association, my lords, which is I was, and SGU. That's where the dispute is, whether it should be SGU, whether it should be golf promoters, my lords. That's the state level. Below us are, my lords, the golf clubs. Various golf clubs. There's the Shillong Golf Club, there's the Tura Golf Club, my lords. There may be the Army Golf Club. In this case, the my lords, Assam Rifles Golf Club. There are various golf clubs. Now, these golf clubs, my lords, they affiliate themselves with a certain body, which would be the state body.
So, what about the requirement that they have a golf course?
My lords, it is not a requirement.
That's written somewhere.
That is for the golf club, my lords. I'll come back. The state society does not have to have a golf club.
My lord, kindly see page number 51
of
the IGU regulation. Since that issue raised.
No, only that only because Dr. Murjika has thrown a cat among the pigeons, so that's why we just.
My lord, Dr. Murjika's submission is a bit away from the present controversy right now. Lord, kindly see page number 51 and 52. Grant of affiliation and recognition of the writ petition.
51 of the writ petition?
Yes, 52.
I'll come to this. My learned friend did not take your lordships to this. I'll come to 52. This. Under what circumstances can you de-affiliate?
52. Lordship, kindly see this one. It says grant of affiliation and recognition.
Yes.
The council shall have power to make, rescind, by laws relating to affiliation of an affiliate, provided, however, that an affiliate may not be a member and may or may not have any voting rights. When granting affiliation, the council shall have the power to impose such condition as it may think fit. And the decision of the council in this regard shall be final and binding, provided that if the activities of any affiliate at any time is, in the opinion of the council, are detrimental to any of the aims and objective of the IGU, the council shall have the power to cancel such affiliation. The council shall have the option to charge such amount as it may deem fit from time to time as the case basis for affiliating affiliation, and also entitled to waive payment of any charges. The council shall have the option to grant affiliation with or without membership or without voting right as may deem fit from the time as the case may be.
Let's hear Mr. Paul on this. Yes. We've spent enough time.
Yes.
Already over an hour.
My friend has taken up the better part of
Yes.
Well, it's 3 issues. So I was pointing out, Malaj, what is the hierarchy? Based on the hierarchy, Malaj, now what are the admitted facts for your lordships to appreciate the law? Is, Malaj, that I was the affiliate body in respect of golf in Meghalaya for the last many years.
Yes.
There has been no other body affiliated. Now, to understand, Malaj, whatever has been argued before your lordships with regard to, Malaj, the power of, Malaj, how IGU functions, we'd first have to go to the Memorandum of Association and the rules and regulations. I'll take your lordships to that first, Malaj. The lordship may very quickly have a look at it. Before that, Malaj, a query had fallen from this Honorable Court as to when was IGU first recognized, established. It's at page Annexure 6, Malaj, page 40. It's established in Calcutta on the 28th day of December 1955. So 1955 onwards, it is the body.
Is a body from 55.
Malaj. If my lords have page 42, Malaj, it will be clear what is IGU and what the functions discharged by them, whether they're in the realm of public function or private function, Malaj, it becomes very clear.
Yes.
Page 42, my lords have it.
Yeah.
Well, it's the name of the society is in the Indian Golf Union, hereinafter referred to as the Union. The registered office, not relevant, it's para 3. The objects for which the Union established in 1955 and recognized by the Government of India. My lords, may kindly take note of this. Recognized by the Government of India as the governing body for golf in India. So prior to 1955 also this body existed, my lords. It was registered in 1955, given recognition by the Government of India as the apex body for golf in India. Are the following, and it is declared that the several sub-clauses of this clause and all the powers mentioned in it are to be cumulative and in no way case of generality of this sub-clause to be narrowed. My lords, we'll skip all this. Application for construction of generic or otherwise. Well, it's first A, to promote the game of golf in India. Well, it's E, to select teams of golfers to represent India in all national and international tournaments, including but not limited to Asian Games, the Olympics, the Commonwealth Games, World Amateur Team Championships, the Asia Pacific Amateur and the Junior Championships, the Asian Amateur, SAARC, etc. So practically, my lords, wherever India is represented in golf, it is done by IGU. Then, if my lords kindly have a look at IJ. Well, it says I is also relevant, my lords, to maintain liaison with foreign countries and all Indian and foreign golf federations, unions and tours. To maintain liaison with Government of India and Indian Olympic Association in the interest of golf. Then L, my lords, to accredit such bodies involved in various aspects of the game of golf as may be deemed fit by the council. So this is the power, my lords, the source power under which these state associations are affiliated. Then to apply for, receive and disburse grants from the Government of India and other appropriate bodies, to carry on any kind of lawful activities which can conveniently be carried out with the foregoing or which are necessary to be carried out for the attainment of the foregoing. So what essentially can be culled out from here is, my lords, it is the apex body. It practically maintains the entire golf situation or scenario in the country.
It's the apex body.
It is the apex body, my lords, and more importantly, which is recognized by the Government of India.
Yes.
And, my lords, N would be very relevant, to apply for, receive and disburse grants from the Government of India and other appropriate bodies.
So your recognition and funds, I mean.
My lords. Now, also, my lords, at 5, it says that in case my lords, at some point of time, the union is to be, my lords, it is to be liquidated, then also the properties do not go back to any of the members. It goes back to, my lords, any other association which would be otherwise in charge of golf.
Like any other society.
My lords. My lords.
Yes.
Now, my lords had gone to my learned friend, Mr. Mosika, had taken this honorable court to B and N of the rules and regulations. Well, it's B is affiliate.
Yes.
And N is, my lords, the State Golf Association, means the State Golf Association of any of the state union territories which is it affiliated to the Indian Golf Union. Now, my lords, if we can skip here and we can go back to affiliation. Before that, my lords will kindly have a look at 62, page 62. This is regulation 33. This is the clarification that my lords wanted, my lords. These are the zones that are created. It says zones. The East zone, it shall include all member clubs and state associations situated in the following states. So Meghalaya, when we say Meghalaya, my lords, it covers all clubs.
So you'll be the apex body of
in respect of all clubs, which we were.
It's just same. It's like they become like district associations, and you become the state federation.
I am the state association. Yes, under me is all golf clubs.
Yeah, and like the other sports associations are organized that way. District become the state federation. That's all. Yes.
So basically, my lords, that serial number 6 is Meghalaya. Now we come back to affiliation. What my learned friend was reading before, my lords, it is very important. 7, if my lords kindly have a look at grant of affiliation and recognition.
Yes.
Yes. The council shall have the power to make, rescind and vary bylaws and relating to the affiliation of an affiliate, provided, however, that an affiliate may or may not be a member and may not have any voting rights. Now, it says, Millets, while granting affiliation, the council have the power to impose such conditions as it may think fit, and the decision of the council in this regard shall be final and binding, and provided that if the activities of any affiliate at any time, in the opinion of the council, are detrimental to any of the aims and objectives of the Indian Golf Union, the council shall have the power to cancel such affiliation. This is the only source of power under which, Millets, an affiliation can be cancelled, contrary to any of the laws that have been, any of the judgments that have been placed before your lordships. If it is detrimental to golf, Millets, or the aims and objectives
but
of...
But you have the rider before that. It says that it's conditional.
They will impose conditions on us.
It says that they'll impose such conditions when they think fit, and this is the council's regard shall be final and binding.
My lords, it is binding on you.
They will impose conditions on you, whatever conditions
it's
may
binding.
be, A, B, C, D is binding.
Yes, it's binding.
And provided if the activities now will
Now,
come
in
under
the
conditions
course after my affiliation,
will activities amount to violation of provisions that they've given.
Violation of any of the stipulations contained at the time of affiliation,
yeah, that means,
or it is detrimental to any of the interest of golf, Millets, of IGU, then I can be de-affiliated. Under these two circumstances.
Under the conditions given to you.
Lordship.
Number one and number two.
I'll take your lordships to my affiliation.
Activities which are not promoting golf.
Well, I'll first take your lordships to my affiliation.
Yes.
This is at page 38. No, this is MSA. Where's our affiliation? Page 39, my lords, Annexure 5. If my lords kindly have a look, this is of 2021. Yes. Well, this is continuation. So it says, dear sir, this is to confirm that the Meghalaya Golf Promoters Society meets all the laid down criteria as on date as per the IGU MOA and RNR of 6 June 2018 and is the affiliated State Golf Association of IGU in the state of Meghalaya. You are requested to forward all information from time to time on the activities conducted by SGA. That's it. So I meet all the criteria. Thereafter, my lords, now your lordships will kindly come to the letter by which my affiliation is cancelled. Now, at Annexure 3, page 37, my lords, may kindly have a look. This is to inform you that based on the visit report of the Indian Golf Union team to Meghalaya and after due consideration of the documents and reports available with IGU, the Governing Council of the Indian Golf Union in its meeting held on so-and-so has approved the withdrawal of affiliation of Meghalaya Golf Promoters Society with IGU with immediate effect. So they withdraw my affiliation, Millets, based on apparently some team visit and on the basis of documents available with them. They don't say...
You're not aware of.
I'm not aware of anything. I'm not aware of anything. Now, in their counter affidavit, Millets, they say that they have issued some notice to me under which I was required to give some documents which I have not given. I'll take your lordships to that as well. If my lords, I kindly have the counter affidavit. If my lords have the counter affidavit, this is filed on the 7th of May 2025, page 19.
7th of May? The one we have is 14th of May.
Mine says it is affirmed on the
14th May.
It says 7th of May.
That's immaterial.
Verified on that. Fair enough. Well, it's at Annexure 19 page, Annexure A page 19, my lords will kindly see. This is the so-called email that they say, and which my learned friend, my lords, had in a way sought to justify by saying that it is a regular email that is sent to everybody, and on the basis of which they have taken a decision. Now, if my lords kindly have a look at it, it starts with, Dear State Golf Associations. It says, Dear all, pursuant to our earlier emails on 2023 with regard to the submission of annual documents by the state golf associations, it has been discussed and deliberated in the IGU Council that all SGAs should be compliant with the IGU MOA and NSDC of 2011. In view of the above, it is once again requested that all affiliated SGAs to submit the below mentioned documents to IGU relevant secretariat for updating its records. My lords may kindly take note, for updating its records. Then they say, my lords, kindly give us all these lists. Now we say, my lords, all information so and so, so and so. We look forward to your support, and you may reach out to IGU Secretariat for any assistance, and so and so, so and so. At the next page, at page 20. Now, this email, my lords, would kindly see on top, my lords, to whom it has gone. It says Farzan Hirji, Brijinder Singh, so and so, my lords, Tapan Mohanty, Secretary of Bhubaneswar Golf, AS Motion Row, so and so, Rohit Shetty, President, Golf Karnataka. So basically, my lords, it's gone to all states, including Meghalaya Golf Promoter Society, my lords. I am there, one of them.
Where is it?
Well, it's in between somewhere. Well, I'll just give the line 1, 2, 3, 4, 5, 6, 7th line. On the 7th line in the middle, my lords will kindly see Meghalaya Golf Promoter Society.
Yes, yes.
Then your lordships will kindly see Bengal Golf, Punjab Golf, Tamil Nadu Golf, Chandigarh Golf. So it's basically to, my lords, it's a random letter that is sent.
Yes.
Now, to justify, my lords, the fact that they have not done anything and it was one fine day, my lords, they decided to do whatever they did, they file an affidavit before this honorable court and seek to mislead this honorable court to saying that no, we had issued notice to them. To which they have never responded. Now, the next letter is, my lords, even more interesting. If my lords kindly have a letter, this is of even date 28th of April 2025. Now, there is a certain Mr. Sham Singhania, my lords.
Yes.
Now, your lordships will again very interestingly see the language of the subject. Application of Shillong Golfers Association as the State Golf Association of Meghalaya. So somebody, my lord, somewhere decides at some point of time that I want to become the body and therefore I make an application to IGU. This is the genesis of the evil. And thereafter, my lords will kindly see, dear Mr. Singhania, this is with reference to your emails dated so and so and so and so, and your application for affiliation with the Indian Golf Union dated 4th December 2024. So 4th December 2024, my lords, somebody makes an application somewhere. And 15th March 2025. We are pleased to inform you that the Governing Council of the IGU in the GC meeting held on 26th April 2025 has approved the affiliation of the Shillong Golfers Association as the State Golf Association under the aegis of IGU. I am enclosing herewith a memorandum of association and rules and regulations of IGU. You are requested to ensure that Shillong Golfers Association conforms to the rules and regulations and policies laid down by IGU. Further, you are requested to regularly update the IGU with activities and developments of the association, maintain active coordination and communication. We look forward to working.
Now, one thing, Mr. Paul, all well and good.
My lords.
The action they seem very colored,
My lords.
colorable, exercise of power. But how will you bring it under the original
Article 12. I will, my lords. I'll satisfy you.
Yes, that is amenable.
Well, it's now, insofar as the law is concerned.
Even like amenable jurisdiction.
Well, it's even, well, it's insofar as the law is concerned.
Article 12 is a bit straight-jacketed.
I'm sorry, my lords.
Article 12 is straight-jacketed, even amenable where it's more, expensive.
My lords.
Yes.
Now, why I place this is, my lords, the fact that how the genesis of the entire matter came in. Now, the other aspect of the matter is, my lords, now the law as it stands, and to my humble understanding, my lords, which your lordships are very well aware of, in view of whatever is the law that's been called out, my learned friend was kind enough to place the judgments of the Honorable Supreme Court in this regard. It's, well, it's A, there's a spot. B, the fundamental principle on which this operates is there is no law operating made by the union government or the state government which operates or actually covers the entire spot. That is fundamental. If there is a law brought in by Parliament, my lords, that would be supreme. So any other body that is there would automatically cease to exist. Now, in the absence of any other law, what happens is, my lords, the government of India recognizes body A, body B, body C as bodies which are there to, my lords, hold the sphere insofar as that particular sport is concerned. And under that, my lords, there are these branches and state associations. Now, to my humble understanding, my lords, BCCI says two things. A, my lords, it may not be per se state under Article 12.
Yes.
But it is performing public functions.
That's what you have to...
Now, which is why, my lords,
that is what you have to
emphasize.
Show that this action is, it's impinging, it's a public...
Well, there are two aspects. Your lordships will kindly see there are two aspects of the matter. A, there is no dispute, my lords, that the fact, and it is an admitted position, that IGU is the apex body insofar as golf is concerned in India. It maintains everything. So my lords, in all practical purposes, it was equivalent to BCCI. Since BCCI is the only authority that's available with us right in front of us, my lords. That's number one. Now, the dispute at hand, what my learned friend was trying to carve a niche, my lords, saying that it is within the realm of private law dispute and not a public law remedy, a public function. Now, the question is, my lords, it is not a dispute between two people regarding a certain act to be done or not to be done. It's not a contractual dispute. Insofar as we are concerned, both the IGU as well as the state federation, my lords, which I've pointed out, state association, are discharging public functions only for the purposes of promoting golf in the country. That is the fundamental principle on which we are working. Had it been a golf club, my lords, then there is an individual right that we are talking about.
That's different.
Here there are two bodies, my lords, one at the state level, one at the central level. Now, the central body, my lords, de-affiliates or de-recognizes the state body. That, my humble submission, is purely within the domain of public function. Because both of them are discharging public functions, my lords. IGU at the central level, state, I'll just call it, my lord, SGU for the term, for our convenience. SGU is also discharging public functions within the state, my lords, for the purposes of promotion of golf. Now, what happens is, IGU receives grants from the Union of India or the Ministry of Sports, as well as the Indian Olympic Association under various heads. They also give money to the state associations for the purposes of promotion of the sport, my lords, at the local level. So, both these bodies are actually discharging public functions. So, any inter se relation between them, my lords, would otherwise be a fiduciary relationship. It is not a private dispute, my lords. I don't have a contract with IGU. I don't work under IGU. I am also an elected body, but I am elected body only in respect of the state. Above me is IGU, I report to IGU.
Okay.
So, it's more of the federal structure, my lords, which is otherwise there. So, per se, my lords, the relation insofar as their relation to me...
Alternative dispute resolution mechanism there will not suffice.
My lords, that I will just...
Now you have to, yes.
The alternative dispute, my lords, that will go in one word. That only applies to affiliates. Admittedly, I am de-affiliated. On the date of the dispute, I am de-affiliated. So, if I am de-affiliated, that provision does not apply to me. That's argument number one. The more important argument is, my lords, that deals with two state associations or other associations, my lords, which might have a dispute between them, that they say that you don't go to a court. You basically resolve the matter under the aegis of the Indian Olympic Association. But the fundamental issue, my lords, under 33 would be that I have to be an affiliate for that provision to apply to me. The admitted position is that on the date of the dispute, where the dispute occurs, I am de-affiliated. So, if I am de-affiliated, my lords, I cannot be, the burden of somebody who is affiliated, that cannot be put to me. So, I go, even under that, my lords, I go.
You're restricted only to that. Even if you're an aggrieved, de-affiliated body, you're stopped from approaching, taking recourse to that. That is your submission.
No, I am saying, my lords, that provision otherwise also does not apply to me. I'll take your lordships to that provision and I'll read it. Your lordship, may I kindly just read it again with me? My lords have taken the trouble of reading it. 66, my lords, at page 77. It says, all unresolved disputes shall be settled by the Arbitration Commission of the Indian Olympic Association, and all... My lords have it, my lords. I'm sorry.
I feel it is.
I think we've taken up the first half of this honorable court, my lords, already.
Interesting point, but sometimes time flies also. Yes.
If my lords have it. Page 77.
Yes.
My lords, your lordships may kindly see. All unresolved disputes shall be settled by Arbitration Commission of the Indian Olympic Association, and all affiliated members of IGU. So, as on today, my lords, I am not even an affiliated member. That's their case, and it is my case that I am a nobody. Shall voluntarily surrender the right of seeking redress in a court of law. So, the second part deals with waiver, my lords. The question of waiver does not come because I am not an affiliate, as on today. And it says not all unresolved disputes shall be settled by the Arbitration Commission of the Indian Olympic Association. Now, what was placed before your lordships, my lords, was the memorandum and rules of the Indian Olympic Association. We're not dealing with the Indian Olympic Association. It simply says that if at all you want, if there is an arbitrable dispute, you go somewhere else. Now the question therefore arises, my lords, is the act of de-affiliating a body an arbitrable dispute? In my humble submission, my lords, it is not an arbitrable dispute because purely in the realm of a public function.
That's what you have to satisfy this court. Anything that's not arbitrable.
It is not an arbitrable dispute, my lords, because it does not emerge from a contract between body A and body B. What was sought to be urged before your lordship says?
It just come under the broad definition of other authorities, the actions which are amenable to jurisdiction.
That is not denied. They don't deny it, my lords. As a matter of fact, the authorities which have been placed before your lordships go on to buttress that fact that they are other authorities, may not be state within Article 12, but are amenable to 226 of the High Court. That's what BCCI says. The question therefore arises, my lords, is the action.
1 second, will you have to make a reply?
I may be allowed 5 minutes reply, 2 minutes reply.
I don't think it will be then anyway. Yes, please.
My lords, if my lords, please, my lords, we can continue tomorrow.
Yes, because that's a very interesting point that we would have to address. Why is not an arbitral dispute?
Well, it is.
When you bring authority, why not arbitral dispute? And why
what would constitute an arbitrable dispute, my lords? In case of an arbitrable dispute, one of the fundamentals, as we understand it, my lords, is that there has to be a binding contract between two people.
Some conditions of the, but then as per that letter, what did they say? Regarding the conditions. So whether those even the plain de-affiliation will be an arbitral dispute.
It won't, my lords. It won't. Because fundamentally, my lords, they would have to satisfy, if somebody is taking the plea of an arbitrable dispute, the onus shifts on them to first prove, my lords, that there is a contract between the parties, that I have voluntarily and willingly entered into that contract, and, my lords, the action which I am now complaining of before your lordships is within the realm of an contractual dispute between both of parties, redress of which has to be to arbitration. The onus would shift on them. That's one. I will discharge my onus to show, my lords, that it is not an arbitrable dispute. Primarily because
I breach of Article 14.
I am simply saying, my lords, that it is in the realm of a public function. If it was not, my lords, if it was a private function per se between both the parties, my lords, then it was a different issue.
Yes. Well, we'll continue tomorrow then. Yes.
We can continue tomorrow, my lords.
Yes. Yes, arguments continue tomorrow. Interesting point.
My lord, may I just pray if lordship find inconvenient day after tomorrow?
Then
we'll lose the.
While it's still fresh in my mind.
My friend can respond day after tomorrow, my lords.
Yes.
I'll conclude.
Once you stagger it, then
because what happens is that day's break is going to break the entire flow.
I mean,
and we've failed a considerable amount of the time of this honorable court. Yes. We'll conclude it.
Item number 5.
May Lordship, this matter is related to the benefit of ACP and MACP of cyber category, my lord.
Have you what's it for hearing?
Yes, additional affidavit, my lord. They have filed additional affidavit, my lord. I have received the copy.
Yes. What do you see in the affidavit? What do you see in the additional affidavit, Dr.
My lord, what I've said, my lord, para 4, my lord, kindly sees, my lord.
Of
my affidavit, my lord. Filed on 14th of May. It's a small 2-page affidavit.
Para 4.
My lord.
Yes.
It says, my lord, that the matter was initially proposed for consideration to the Ministry of Home Affairs. However, due to financial implication, the same has been referred to the Ministry of Home Affairs by the Ministry of Home Affairs to the Ministry of Finance. As such, delay has been caused in complying with the judgment noted so and so. So, my lord, the sum and substance, my lord, it is under consideration, my lord. It's been referred to Ministry of Finance, and the moment we get concurrence from Ministry of Finance, we will implement it.
Yeah, it's listed for 3 weeks. Yes, for the orders. Yes.
Lord, sufficient time has been given to
yes,
the
Mr. Kumar, what to do? You know how they
my
are.
Lord, we don't know how long this contempt will go, my lord.
3 weeks, 3 weeks.
Item number 6.
We hope it's complied by then.
My lord, deep your lordship.
May please lordship. In respect of respondent number 184, I have filed the rejoinder to the affidavit filed by the respondent number.
Why
4.
do you not file affidavit?
Lordship, There's some problem, Your Lordship. I'll be filing in the
What's the problem?
signature, Your Lordship.
Because of the day.
No, Your Lordship. This week, for 1 week time.
MSC submits that the action will be filed positively within 2
1
days. Within 1 week. Okay. Let's set out on something.
Authorised, Lordship.
7.
May I please, Your Lordship, respondent number 123 haven't filed affidavit.
I'm praying for 2 weeks time. We have written to the department, Lordship. We are yet to receive.
Which department is this?
TTDC, Lordship.
What's the matter about?
It's land dispute matter.
Boundary dispute, Lordship.
Boundary dispute.
Boundary dispute of all the villages. 5 villages.
Impugn which order? Where's the order impugn? By the EC?
EC, Lordship.
We set it aside, Mr. Krem.
No, Your Lordship, here what happened?
It's signed by one member only. How
No,
big
no.
executive committee signed by one member?
No, this orders, Lordship, they want the boundary to be as per the...
Impugn orders this one, 4th September 2024.
Annexure 7, Your Lordship. Annexure 7.
Annexure 12? No. What's Annexure 7?
Yes, Lordship. Annexure 14.
Annexure 12 or Annexure 14?
My copy is Annexure 14, Your Lordship.
That order is 4th September 2024.
4 September 4th, yes, sir.
They don't have to set it aside. We'll pass orders. You take it.
We will be allowed, Lordship, to file our affidavit, Lordship.
No need to file affidavit because this is against the what to say. This is a matter before it's a order passed by the executive committee. You know, it has to be signed by at least 2 members. That's the only consideration. You take instructions. We'll have it after tomorrow. Yes, take telephone instructions. Yes, you need to file affidavit also. They can reconsider it.
Item 8. 8. 8.
Yes, Your Lordship, this is same matter.
Same matter.
Asbestos.
Same Lordship.
Same defect.
Same effect. One is for item WPC 442 is 1 village, Lordship, and 443 is 2 village, another 2 village.
Yes. After I said after how many days? 2 days.
Your Lordship, in this matter, respondent number 123, they haven't.
Doesn't matter. We will set aside orders. You come after 2 days.
Thank you, Lordship.
9.
Is joined a file.
Lordship, we have already filed in reply to the respondent number 1, 2, and 3. For the private respondents, we will be filing in the
Where's,
course of the day, Lordship.
Where's 5 to 15?
Representative, we have 6 to 15.
Why not filing affidavit?
They have
We
already
have
filed
filed
a-
the affidavit, Your Lordship.
Who has not filed?
The petitioners to file the rejoinder
Put a-
to their affidavit.
Oh, what about 1, 2, 3? File.
We have filed the affidavit. They've also filed the
Number 4?
rejoinder. Who's number
Lordship, they have
4?
filed, Your Lordship.
You want to file rejoinder now?
Lordship, we have already filed in reply to the respondent number 1, 2, and 3.
No, now you've taken time.
For the private
6
respondents.
to 5 weeks. 6
For the
15.
private respondents, we will be
Once
filing in the
more
course
time.
of the day, Lordship.
Okay. Submitted by consultation that the rejoinder affidavit to be affidavits of the response 615 will file in the course of the day. We listen for hearing.
Lordship,
we can list it for hearing.
This one's rejoinder has been filed, it can be, Lordship.
Yes?
Lordship, once rejoinder has been filed, it can be, Lordship.
Of course. You sign course of the day. This is a matter for hearing. Yes. Thereafter. On so and so, yes.
Item number 10. Lordship, in this case, we're praying for a week's time, Lordship, to file
No, for other
affidavit.
respondents. 1 to 4 state. 5 to 7 MS Hamani. File affidavit.
Here we've received the instructions, but there is
Election is supposed to be held on the month of January 28th. January.
VC?
Yes,
VC, Your Lordship.
You are the ones controlling the VC now.
Yes.
In this one, this is Sharif.
Without election, they are still
Oh,
continuing.
this is Saiful.
2 weeks because they are just simply delaying matter.
Last MS. Otherwise, you're clinging on to power. Yes, MST Yangi, be the EAG, which also pray for further 2 weeks time to file affidavit. Similar Prim versus M. Rahman for
Okay.
5, 6, and 7. Prayers allowed this after 2 weeks, yes.
Lordship.
Kindly file it.
10 also is the same.
10 is also the same, Your Lordship, because the VEC is now
Respondents are
shifted.
the same.
Yes, all respondents
VEC
also.
They are
has
there
shifted.
also.
Yes.
No.
Yes, yes.
Are you there in 10, 11
Yes.
also?
11 also they are correct.
In 11, Your Lordship, the VEC has shifted from Demdama to Batabari. So that change has to be made by the petitioner, Your Lordship, because they've made the BDO.
They have been, yes.
The BDO Demdama has been made a party, not BDO Batabari.
But have you filed affidavit?
We are yet to file the affidavit, Your
Take
Lordship.
down item number 11. Item 11, it is apprised by the AEG that the concerned
VEC.
The concerned BDO has not been implemented, as much as the it should be under the BDO of
Batabari, Your Lordship, not Demdama.
Bari or Batabari?
Batabari. Batabari.
Yes.
Them actually prior to
Petitioner
their
will take
resolution.
the time. What's happened? They have also, they have reorganized.
Reorganize that, Your Lordship.
In other cases, same thing happened. You take
Oblige, Your
instructions.
Lordship. Most blessed Lordship.
My lord, item number 12 and 13 are connected matters, my lord. Our affidavits, my lord, we are expecting in a day or two, my lord.
No, one thing, Mr. Eubin.
Yes, my lord.
Last time we submitted that.
Yes.
4 and 5, who's the 4 and 5?
4 and 5, I am representing, my lord.
Now
Fatco. Yeah, yes, they are the same. We have confirmed, my lord, they are the same party, my lord.
So yes, so you'll be at the appearance now.
Yes, my lord.
If Mr. P. Eubin submits that, he will be representing the response number 4 and 5 in incident matter. Yes, you've given copies.
Yes, I have some.
When are you going to file affidavit?
My lord, we have already prepared, my lord. There's one more matter, my lord, connected. Simratha, my lord. That is WPC 91. That's listed on 12.6. So may this matter be listed there, we'll file it in the meantime.
Eubin submits that praise allowed to file affidavit and has also submitted that the matter connected to WPC number?
WPC 91.
25.
Yes, my lord.
So which is to be listed on 12.6.
Yes, my lord.
All this together 12.6. 2021, yes.
Hello.
14.
Together with this together with 91 of 2025 on 12 June 25. Yes.
Your Lordship, the state has filed the reply, except the respondent 3.
MPSC?
Yes,
Yes. Already you've obtained instructions.
We have written to the department.
What are the instructions?
They have not replied as yet.
No, we have asked Secretary MPSC to come here then.
2 weeks time maybe allowed, Lordship. We'll allow affidavit.
Any urgency?
Urgency is their Lordship because...
Selection to which post?
A forest ranger and
Ranger, Your
assistant
Lordship.
conservator of forest, Your Lordship.
Because, Your Lordship, this advertisement are made after 10 years, and if the next advertisement
After
will
10
come,
years?
Yes, Your Lordship. If the next fresh advertisement will come, the
Lordship,
petition
they
will be
took
over
part
age,
in
Your
the
Lordship.
selection process only when the result is not favorable to them, they come before this honorable court, Your Lordship.
Naturally. If it been favorable to them, they won't be before this court.
And Lordship, for the 24 advertisement, Your Lordship, they are yet to reach.
Yes, Your Lordship. If the advertisement are fill up, Your Lordship, the petitioner again, if they will apply,
As
it will be
Chanda
over
has reviewed his prayer for time to file affidavit, stop. It is expect in consideration thereof 2 weeks for the time is given. Is expected next date. The affidavit to be on board. Yes.
Your Lordship, last time we filed this case for the stay, Your Lordship. If kindly consider, Your Lordship.
Interim order will be considered next date.
I think the result has already been out, Your Lordship.
Even if the affidavit of the MPSC is not on board, let us give the direction, at least some instructions, if even not affidavit, yes.
15.
Apply.
Highly applied. Please, Your Lordship.
On behalf of the state, we are awaiting instructions.
Why no one appeared this matter last time?
Last occasion, it slipped my attention. My apologies.
You're appearing for whom?
Number 7, madam.
Who's he?
Siva William.
Number 6? This is council. And MSP Chitri for 5. Who's 5? 5 is? What's the matter about?
Your Lordship, for respondent number 3 and 4, we had to. There was some problem with those postal receipts, so we'll file our affidavit of confirmation on the next day, before the next date, Your Lordship.
The state is one.
What is the refusal? Umran, who's appearing? That Rampashno.
That would be 3. Respondent number 3 and 4.
And 4.
Yes, Your Lordship.
You're not able to serve them.
We've already taken steps. We're yet to file our affidavit of confirmation.
Because the petitioner prays that he will have further time to ascertain service respondents 3 and 4 and to file affidavit. What about the others?
Affidavit. Your Lordship, at this stage, we will not file, Your Lordship.
You're for the oil company?
Yes, Your Lordship.
I'm awaiting. I'll pray for 3 weeks, my lord. I'm awaiting instructions.
2 weeks time is allowed to state respondents as also the respondent number. Your respondent number? 7. To obtain instruction to file affidavit. Yes.
16.
Yes, Your Lordship. Lordship, I'm still waiting for the instruction, Your Lordship.
Please, Lordship. I'm praying for 2 weeks' time.
1 second. Yes. 2 weeks' time has prayed. Elections held since last June. Allowed to respondents for affidavits. 2 weeks for that time. Yeah, any hearings will, how many hearings? Huh? Yes, we will take it up at 2 o'clock if anyone has hearings which we want to do.
Your Lordship, item number 23 may kindly be adjourned for today, Your Lordship.
23. Any urgent matter you have?
In relation to item number 27, that my senior finished, Lordship.
23 give it tomorrow.
23?
Yes, Your Lordship.
24? Ready? Ready the matter? We'll have to take it at 2 o'clock.
You can take it up next week, Lordship.
25?
25, Lordship.
Ready?
Instructions there, Lordship.
You ready?
Lordship, sir has got.
What's the instructions?
Lordship.
Yes, ask. Yes, 1 week.
Your Lordship.
24.
Lordship, item 17 and 18.
You want to 2
No,
o'clock?
Lordship, on the next day, Your Lordship.
Why? All allergic to doing after lunch.
No, Your Lordship.
18 after 1 week also is.
Lordship, in relation to item number 27, I will be allowed to withdraw the same, Your Lordship.
This number 27?
Yes, Your Lordship.
Why?
The petitioner are no longer interested, Your Lordship.
Okay, Mr. Armojao, could I have some please that be without one instruction that we would have to withdraw this application. They is allowed. Matter stands closed and disposed of the draft. Why are you afraid of the bench?
No, no. In fact, moreover,
the same order will come.
Moreover, the lease agreement will expire on 31st, Your Lordship. The matter will become infructuous, Your Lordship.
Yes.
How do you?
25?
Let it come, Lordship. I'm praying it come next week, Lordship.
Why you are not the L1 also?
Lordship.
The contract was executed a long time back.
Yes, the contract is
nothing remains.
Only thing is that, Lordship, we were otherwise qualified, Lordship. Lordship, we have not.
Material instructions or order instructions?
Lordship, we have, in fact, Lordship, not received instructions, Lordship. We have.
We come tomorrow, Mr. Paul. I think we'll be there tomorrow.
Yes.
Lordship, let it come next week.
Civil suit of them still.
That's what they're waiting for material instructions. Let them wait for some time. Yes, list day after tomorrow.
Lordship.